you have anyone from legal services today? No? Oh, okay. So maybe it was off. That's not it. We should have this here. We did not see, we have Marshawn Jackson here. Is Marshawn Jackson here? No. Service person. Let's see, Attorney Ozinski.
Good morning, Your Honor.
Good morning. No one's appeared on behalf of Marshawn Jackson. There was personal service. You can submit default.
Thank you, Your Honor.
Thank you. Is Griselda Perez here? No. She's not. Problem service. See, Mr. Lawrence is present, and then Jessica Coleman, you had a question, ma'am?
Yes, on my paper, on my notice, it says that I should be in courtroom 4. Am I in the right courtroom?
Correct.
Okay, thank you.
No problem. Someone on a Motorola Moto G stylus, can you unmute your device, please? What's your name?
Griselda Perez.
Okay. Okay, we do have Ms. Perez here. Okay, Griselda Perez, you're not driving, correct?
No.
Okay, for Ms. Perez, Ms. Coleman, and then Mr. Lawrence, today's the day scheduled for a pretrial. This is for an eviction matter. I'm gonna play a video for you that will advise you of your rights. It'll also go over resources that you may be eligible for that can help assist you during this time. And then it also will advise you of potential ways that you can resolve this matter. We do have representatives here from legal services as well as our eviction diversion facilitator. You are welcome to meet with either or both of them at the conclusion of the video. One can do an intake. The other, the legal services can do an intake to see if you can be represented by their office at no expense to you. Are you smoking a cigarette, ma'am?
I don't smoke.
Excuse me?
I don't smoke.
Okay. I just saw something in your hand. Are you okay?
Yeah. I'm just not feeling well.
Okay. Then there is a eviction diversion facilitator who can go over the resources with you to discuss if you're eligible. Let me have the video played for you now.
It's on a different screen.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Ms. Perez? Have a date for Coleman. June 25th at 1:30. Ms. Coleman?
Yeah,
Your matter is scheduled for a hearing in person at the court June 25th at what time? 1:30. At 1:30.
June 25th at
At
1:30.
1:30. Correct. Ms. Perez?
Mhm.
Griselda Perez, can you hear me?
Yes, can you hear me?
Yes, remove whatever's covering your screen.
Mhm.
Ma'am? Remove
Sorry, I
what's
was
covering
writing
your
some
screen
stuff down.
so that I can see your face.
Yes, ma'am.
I need to see your face. Are you
Can you
under the
see me?
influence of, are you under the influence of something?
Oh, ma'am.
Okay, you need to appear in person today,
At what time?
right now.
Okay.
Thank you.
Is there a Oh, do I need to wear a certain
Excuse me?
attire?
Yeah, you need to wear clothes.
Yes, ma'am. Okay,
Yeah,
that's what I'm asking.
if you don't
Is there
appear today, a default will be entered. So you must appear today. I need to see you in person.
Okay, excuse me. I just wanted to make sure of the attire because I'm not dressed for that right now, so it's gonna be a minute before I get down there. And what is the address?
We're at City Hall on the 6th floor,
City Hall.
124 West Michigan Ave.
City
Whatever
Hall.
you have on is fine, unless you don't have pants on.
I do not.
I'll see you when you get here.
All right. See you when you get there. Do I hang up?
You still you ain't got your food. He came back.
Mm-mm.
Are you on break?
Okay, Ms. Coleman, did you want to meet with legal services today or the eviction diversion facilitator?
Yes, please.
Okay, can someone put it in the room with, let's see. Ms. Greco. Okay, Mr. Lawrence, this is the same time. Yeah. Your matter is scheduled for a hearing in person at the court, June 25th at 1:30. You're muted.
Hello?
Yes,
What, to pay some rent?
this is an eviction for non-payment of rent.
Yes, I'm already paying it.
I understand you're already paying it. Is it paid?
It's gonna get paid Friday morning. It was at $9.90.
You gotta pay the complete balance and court costs before they'll dismiss the case.
Okay, so how much is the whole thing?
Counsel,
Thank you,
Hello?
Your Honor. Yes, the total amount due and owing today, the total redemptive amount inclusive of court costs is $1,234.15.
Okay, I had that paid Friday.
okay, if you pay in full, they can make or submit a dismissal. Unless you get proof that they have submitted a dismissal, you need to appear on your hearing, okay?
Okay, can I ask why it's so much? Is it because of court fees?
Yes, rent due and owing's $1,055 even. Court cost in the amount of $179.15 for the total of
Okay.
$1,234.15.
Okay, because I got $1,000. I could come up with the other 200 next Friday, but I got 1,000 right now.
Okay, again, if you pay your rent in full, they can dismiss the case. Did you want to meet with legal services today or the eviction diversion facilitator?
No, Friday I could give them $1,000 and I just go talk to my landlord about the other 200.
We heard you 3 times. You're all set, sir.
All right, thanks.
Thank you. On the record in the matter of the city of Lansing versus Vakisha Tyson. This is in file number 24-01862. Council appearance, please.
Patrick Boot on behalf of the city, Your Honor. Jack Rucker on behalf of Ms. Tyson, who is approaching the council table.
Okay, this is the continuation of a jury trial that we just need to move forward with deliberations. I just needed to know if we address anything before I call the jury in and swear the court officer in for them to have their time for deliberation.
I have one matter I'd like to raise to the court.
Yes.
I was reviewing and kind of going over the testimony yesterday. And I would like to make a motion for a direct verdict on count 1. Looking over the testimony of the different officers, no officer testified that they measured the length of the blade, and there is an insufficiency of the evidence gap for the elements to meet the city ordinance regarding the length of the blade. Sergeant Mueller, at best, testified that he estimated it to be over 6 inches. My client said that when she was on the stand, that she didn't think it was over 3 inches, and the officer who actually bagged it into evidence was Officer Shading, and he offered no testimony as to measuring the length of the blade before the close of the proofs. And so, pursuant, Your Honor, to People versus Wolf and People versus Hampton, those are kind of the two guiding case law on city evidence. And then there's also the case of People versus Parker, which established the state analog for the dangerous knife statute. Court of Appeals held that that is a mandatory element of the length of the blade has to be established by evidence at trial.
Your Honor, in response, I would say first, I believe this motion may be late and should have been taken up at a different time before the defense put on their case and closing arguments were given and the jury was given instructions. That aside, I believe Officer Mueller did give enough testimony. There is not a element of this charge that Mr. Mueller has to bring out a ruler and measure the knife. He can have the ability as a person who has been a police officer for, I can't remember how long he's been on the force for quite a time. He's dealt with these charges before. Also, just as a general person who can use their general knowledge, can look at something and tell if it's over 3 inches.
I can't look at something and tell if it's over 3 inches by looking at it. It could be 1 inch less. It could be a 1/4 inch less. It could be 1/8 of an inch less, and it would make the facts insufficient. There is an officer who doesn't have a training in estimating the inch of a knife. What training is that?
He does not have training to tell the exact measurement of a knife, but
he estimated to be over 3 inches, but he couldn't give us the exact length of the knife, and the elements are clear. It has to be a blade over 3 inches.
But there's been evidence presented to the jury, including visual representation of that knife, that they can make a determination on their own whether or not they believe that knife is over 3 inches or not. They don't have, doesn't have to be evidence presented.
It's not the duty of the jury to make an estimation about how long a knife is by looking at a video.
It's not their duty, but they have the ability to analyze the evidence that's been presented to them. They make
can't pass your duty to the jury. It was the people's duty to present information to support each element during their case in chief. You called 3 witnesses. You played video, and nobody ever brought out evidence about how long that knife actually, or that blade actually was. There wasn't even any real inventory information as to what was in the bag. The people were well aware that there was a potential defense, if that's what we call it, that there were other items that were going to be in the bag. Some testimony about a missing check, but some spoons and other silverware. I think there was a question, I think it was on cross, about who would have inventoried the bag. There's no evidence that the contents of that bag was ever inventoried, that they ever took that knife and actually measured it. There was no picture of the knife. There's a video. And you want me to say that because the jury saw the video, that they can estimate what or the length of that is, and that it's over 3 inches?
No, that's not what I am saying is the evidence that was presented in front of them, including testimony of the officer who says he believes that knife was over 3 inches, in conjunction with the video where they can at least see it. They don't know what the exact length of that knife is, but they have the ability to believe I don't think that's 3 inches.
I have the ability, she has the ability to believe she's a millionaire. I think I heard that on the video. Does that make it true?
No, but that gives the jury the ability to believe, to decide on their own if they decide the fact is true or not. They are the triers of fact.
That's not, no, you have to present evidence first. And the motion is that there's been insufficient evidence to even put it before a jury. And I agree. There has not been any information put forth by the people that would establish with any reasonable certainty that this knife was over 3 inches. There was a kitchen knife, which I saw briefly pulled out of a bag on the video. The jury saw the same thing. There was never testimony, did you measure the knife? That's normal questions for the prosecution to ask their witness if you're going to charge someone for having something above the legal limit as it relates to the inches here. Given an example, do you think that we can just let people get drunk driving and we estimate that their blood alcohol level is above a 0.08, or do we actually have to measure it?
But they can be arrested based on their.
But can you put it to a jury based on, I estimate that their blood alcohol level was above a 0.08, or is there a requirement that the people put forth some evidence that shows some measurement?
I think
you don't want to answer that question.
I think we're.
You answer the question first, and then I'll let you get argument.
We don't put an estimation of a intoxication in front of the jury without any other evidence. But I believe Officer Mueller.
It's measured.
Right.
It is measured because there's a requirement that some measurement show that it's above the legal limit. So you can bring it to the jury. We can't just arbitrarily put information before the jury for them to try to sift through and make their own determination. That is the whole purpose of the motion for direct verdict. That's why there is that opportunity available to the defense, so that if the prosecution has not met their burden to bring sufficient evidence to even bring to a jury, that we don't leave it to a jury to try to sift through and make up the evidence on their own. That's not appropriate. It's prejudicial. And it was clearly the element was only that it was a knife above 3 inches. All you had to establish was that it was above 3 inches, and that was never established.
What I would like to say is, Your Honor, I believe that, and I don't have the case law in front of me. I believe only a scintilla of evidence to that element has to be presented to the jury.
Based on what case law are you?
And I don't have it in front of me.
It doesn't have to be only a scintilla of evidence. You have to prove that beyond a reasonable doubt.
That's for them to
decide. The element that you have to prove beyond a reasonable doubt is that the knife was above 3 inches.
But it does not have to be proved beyond a reasonable doubt just to get to the jury.
You have to put evidence before the court, before the jury, that sufficient enough for them to make that determination. You've not put anything on this record to tell if this knife was 6 inches or if it was 2.5.
I believe Officer Mueller was asked directly, do you believe how long was that knife? And his testimony was it was 5 or 6 inches.
No, he approximated it to be 5.
That's the evidence that was put forward to the jury, and it's for them to decide whether they want to believe some, all, or none of what that witness said.
No, because because if it's a motion that is insufficient, now it's my duty to respond as to whether or not that was sufficient enough to put to the jury. I do not believe that given an approximation where the element is to be exact, that it's above 3 inches. That I looked at it, nobody testified as to, or question that witness as to whether or not he was trained to estimate length of a foot. We don't know anything about that. I don't know anything about this officer and his ability to guesstimate how long a knife is. I don't even think that guesstimating the inch is reasonable under the circumstances. If you're going to charge someone with a knife over 3 inches, and you're going to pull out something to measure it.
Your Honor, I would ask for the ability to brief this if the court doesn't want to allow that.
I'm going to take the motion under advisement anyways, because we've already I've already given final instructions and told the jury that there were 2 cases that they'll be deciding for. I do agree that you dropped the ball by not making the motion when you should have been making the motion before you gave your case after the. people
I
had
agree,
rest.
I agree, Your Honor, that I should have made the motion to close the prosecution's proof. I believe that under the rules, I still would have had the opportunity at the close of our proofs that I could have raised it at that point as well. But I recognize I raised it at neither point. The jury's been set out. It would almost be like a JNOV at this point, that if the verdict does come back, I would ask that be dismissed as a matter of law pursuant to this issue. But
I will allow the parties to make a, or to brief the issue if necessary, after the jury makes their decision.
thank you, Your Honor.
Any other matters? We can call the jury in. That guy in the orange is, I don't know. Sorry?
Like her, Sandy, she was here doing the video. He's on the L2 docket. I did put him on notice.
I have to do it when we have the jury's on. Okay.
I put it right on my desk.
All rise for the jury. Okay, thank you. You can be seated. Okay, so we have our 6 jurors here. We've gone over all of the evidence. I'm going to remind you that when you go back to the jury room, that you first need to choose a foreperson to begin your discussions. We'll get you a copy of the full jury instructions. And then if you have any questions, or if you want to review any of the video evidence that was admitted, you'll have your foreperson writing note and knock on the door, and you'll pass that note out so that it can be given to the court officer. You can't speak directly with the court officer. And you should not let anyone know how you're leaning if you make any communication in writing to the court, okay? Let me swear in the court officer, and then you all are free to go and deliberate. Does anybody have any questions at this time? Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them orally or otherwise, and that you will not communicate with them until the time that they are discharged? So help you God. Thank you. All rise for the jury. You're free to deliberate. The person reading this, what?
Like the Sandy.
Oh, okay, but Mr. Wycliffe Sandy, you heard the video, correct? You heard the video that we played, correct? Okay, what day is this?
It's June 25th at 2.
Your hearing is scheduled in person June 25th at 2 p.m., okay? Do you want to meet with legal services, sir?
No.
Okay, what about the eviction diversion facilitator? Okay, you're free to go. Yep, at 2. Did we give him his notice? It might be on the printer.
Nope, that's no.
What's this? Did you get a notice?
No. How do you want to shoot?
Back to all the other.
Just join on an iPhone. What's your name, ma'am?
Sierra Robinson.
Okay.
What's your name, sir?
Larry Ellis.
Ms. Rival, which matter are you here for? Rival, can you hear me?
Good morning, Your Honor. I'm here for. Yes, can you hear me?
Yes. Who are
Can you hear
representing?
me? Okay, sorry.
I
I am here for. I'm here for Short South versus Wycliffe Sandy and Short South versus Kamatha Wade.
Okay, we have that as Clark Brothers Capital. Is that who you're referencing?
Yes. Yeah.
Okay. Okay, Mr. Wycliffe Sandy appeared early. His matter is scheduled for a hearing in person and at the court on June 25th at 2 p.m. Okay, Sierra Robinson and then Larry Ellis. Today's the date scheduled for a pre-trial. This is an eviction proceeding for non-payment of rent. We're gonna play the video for you that will advise you of your rights. It'll also advise you of how you can possibly resolve this and potential ways in which, or resources, I should say, in which you can possibly access to help you avoid an eviction. I'll get you your next court date. You must appear in court for that next date. That date is for a hearing. And then you can meet with legal services. They're here to do intakes today to see if they can represent you at no expense to you. And then we have, can you mute and turn off the screen for the, well, the Woodbridge is gonna come in. If they come in, you can turn theirs off.
I'm
Excuse me.
Carolyn Cohen. I'm here for Woodbridge. I apologize. I was a couple minutes late.
No problem. I was talking about the manager. I think Woodbridge is in the waiting room. The property manager.
Okay.
Thank you. Okay, so again, Ms. Robinson and Mr. Ellis, there's a legal services here that you can meet with if you want to do an intake to have them represent you. And then also, we have an eviction diversion facilitator here with the court that you can meet with to discuss resources that could assist you during this time. We'll play the video for you now.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Avid House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, let's see. Sierra Robinson, your matter is scheduled for hearing in person at the court June 25th at 2.
Okay,
Did you want to meet with legal services today?
yes.
Okay, let me see. Did we have someone else in the meeting from the breakout room stuff? Oh, okay. Let's see. Mr. Tyra, can I put her in the room with you?
Yes, Your Honor. Thank you.
To do room 2. Okay, let's see. Mr. Ellis, your matter scheduled for hearing in person at the court, June 25th at 2. Did you hear me, Mr. Ellis?
Yes, ma'am.
Okay, did you want to meet with legal services today or the eviction diversion facilitator?
Yeah, I will.
Okay, give us just a moment. We'll have Mr. Rosa come back to this courtroom.
It looks like I'm all set. Thank you so much.
Let me see, who's supposed to be here for Kamatha Wade? That's you, Miss.
Miss Rebel, yes. Zoom. Always have to download Zoom.
Yeah, we can playback back.
Oh, gosh, this thing is like,
Let me call Sean.
the battery is low.
Call Sean on that.
Well, I think the battery is low and I asked her to charge it. I know you put it in there, I think I took it right out.
Oh,
Okay, let's see. Okay, can you hear us now, Ms. Rybel? Oh. Okay,
Yes,
are
ma'am.
you, thank you. Are you on the matter of with Kamatha Wade?
I am.
Okay, we do not see proof of service. Did you have service on that?
We did. We had personal service. Looks like that was served on June 6th.
Proof of electronic service, right? I don't see proof of service. Let's see.
If you'd like, if you have an email, I can email that over to you.
It needs to be filed through my file. Was it filed? We don't have it in here. We have a proof of there was a proof of electronic service. But it says that that was on June 17th.
Okay, 1 second. Let me get into my file really quick and I can upload that. I just submitted that.
And you said it was, you have personal service?
Yep. Served personally a copy of the summons and complaint on Kamatha Wade at the address of 342 East St. Joseph on 6th day of June, 2025.
Okay, let's see, I'm gonna still have this reset for a pretrial. If we do receive the proof of service, it does take time for it to process through my file. Then you can submit default. Otherwise, we'll proceed to the next pretrial date.
Okay, could I request a default judgment prior to that date, prior to the next hearing?
25th at 8:30. June 25th at 8:30 is going to be the reset pretrial date. The proof of service, if you filed it today, it probably would be in my queue. Well, theoretically, it would be about today or tomorrow, but tomorrow we're closed and I'm off on Friday. And so I wouldn't even see it until Monday. However, you can call the clerk's office. I'm going to put a note in my file that if there is proof of service received by the clerk's office, that you can submit default. So as long as they see it, they'll know, they can read the note that you can submit default.
Great. Thank you, Your
So
Honor. I
is that all?
appreciate that.
No problem. That's all you have for the morning, correct?
Yes, that's all I have.
Thank you.
All right, have a great day.
Same to you.
Okay.
Ms. Coleman, did you need anything?
All right. I was trying to find my way back to the courtroom.
Did you? Okay.
Veronica said something to me about talking to Mr. Rosa.
Mr. Rosa, yes. Mr. Rosa, are you available?
Absolutely, Your Honor.
Hi.
Okay, I'm gonna put you in the room with Mr. Rosa now, okay, Ms. Coleman?
Thank you.
Thank you, Your
No
Honor.
problem. Great.
Join.
Who's on the? Oh, did the wing tech person leave? They did. Jasmine Miller.
Yes.
Your case has been dismissed.
So I don't have court today?
You do not, the case was dismissed.
Okay.
You're all set.
All right, thank you.
You're welcome. Who just joined on the wing tech device? I don't know if they can. Can you hear us, ma'am?
Yes.
What's your name?
Margaret May.
Monica May, okay. Is Jason with you?
I'm not sure if he's on the line.
Oh.
He has his own phone.
He's here. I see him. He just needs to start his video. Okay, thank you. You're muted, sir, but today's the date scheduled for a pre-trial. This is an eviction for non-payment of rent. I'm going to play a video that will go over your rights and that will advise you of ways that you could potentially resolve this eviction and then possible resources that you can access during this time to help you avoid eviction as well. We do have representatives from legal services here. If you want to do an intake to see if they can represent you, you can do so at the conclusion of the video. And we have our eviction diversion facilitator here who's here to discuss the resources that could assist you. I'll give you your next court date. That's the date you need to appear in person at the court for a hearing, okay?
Okay.
Okay, play the video.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. A conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, Margarita May, and then James, Jason, your matter is scheduled for hearing in person at the court June 25th at 2:30.
Okay.
Did you want to meet with legal services today?
Yes.
Okay. Are you all living in the same unit or separate?
We're living in the same house. He's just upstairs.
Okay,
Yeah, I'm charging my phone.
sounds good. Okay. Let's see, Ms. Greco, can I put them in the room with you?
Absolutely.
Also, I applied for assistance.
Okay, so you need to provide proof of that within 5 business days to the clerk's office, okay?
Okay, I can do that.
Thank you.
You are very welcome.
Mr. Akiniki, did you get your court date? No, she is moving now. Mr. Akiniki? Charged this last night? Last night? My question was, did you charge this last night?
I didn't, David told me he plugged it in.
Okay, you can be seated. Okay, and my understanding is that you do have a verdict, is that correct? Who's the poor person? If you can stand and read your verdict.
Sure. On count one, knife with over 3 inches, find the defendant guilty. And on count two, hinder, oppose, resist, obstruct, to find the defendant not guilty.
You want the jury polled. Juror number one, is that your complete and accurate verdict?
That's mine.
Juror number two, is that your verdict?
Yes.
Number three, is that your verdict? Number four, is that your verdict?
Yes.
I think we released number five, is that correct? Yeah. Juror number six, is that your verdict? Your juror number six.
Yes.
Juror number seven, is that your verdict?
Yes.
Thank you. I want to thank you all for your participation and for appearing, even though it spilled over into the second day. Also for bearing with us with the temperature issues we have in here. It's a little bit better this morning than it was yesterday, but being attentive and taking your time to do your due diligence while in the jury room is the only way the system for justice can work. So I appreciate you appearing today. I believe this will conclude your jury service for this week because we don't have any trials here on Thursday or Friday. So thank you again. You'll be exported out to administration and then you need to receive your payment for today as well. All right. Excuse. Oh, you can bring that when you come. Thank you. Okay, so there was a guilty on count one, not guilty on count two. Of course, it would be the count that we have a directed verdict pending on. So I will set this for a motion hearing. How much time do you need to brief your motions?
Your Honor, I don't know that I need a ton of time, but I am going out of town from the 26th until the 7th.
Well, of course, you knew you were making the motion. The people did not. So how much time did they need?
To right before the holiday, so maybe 2 weeks. To
I don't think
With
we
the
have time
holidays,
until
it'd be the
until
3rd.
August anyways, actually. Is that accurate? We might be booked at actually.
Coming back to the 7th.
And leaving when?
The 26th.
Oh, sorry.
Seventh of just what do we have on
Yeah. 7th.
I'm getting my 8th back. So does the 8th work?
Right. I have several matters in Eaton County on the 8th. Unfortunately, I had them all adjourned that day.
Okay, sounds good. You said 15th, 15th work.
Let me check. Yes, that will work if we can have it at about 10 o'clock. I have an 8:30 in Eaton County.
It'll be an afternoon. It'll be an afternoon.
Afternoon, even better, perfect. I'm completely clear in the afternoon.
1:30.
1:30 on the 15th. Thank you, Your Honor.
Sounds good.
And I don't know, does the court require a PSI? If there were to be, if the motion were to be.
I'm not setting it for sentencing yet.
Until
so,
that is
yeah.
decided. Very good, Your Honor.
Any additional matters for today's record?
None from the city, Your Honor. None from the defense, Your Honor. I appreciate the court's time.
I do have one. There's a City of Lansing versus Ms. Tyson 24L2882601. Just to show cause because you owe $186.
Yes, Your Honor, Ms. Dykeman is aware of that. I did kind of tell her to put that on the back burner while we were dealing with this, but she is aware.
Back burner, she's a millionaire. She's paying that today, isn't she?
I don't have it yet.
No, no, you said, see about you, I saw the video. You said you were a millionaire. You had a couple books
In my
coming through.
mind.
Oh, okay, got it, you're speaking it into existence,
Yes.
okay. Well, when do you think that your millions will manifest so that you can pay this 186?
Hopefully sooner than later.
How long should the judge put the due date?
And you can make payments, you don't have to pay it all at once.
Okay, so if you can give me about 30 days,
And how much are you gonna pay in 30 days?
it's 164,
186.
186. We can do 50, and,
Maybe 50 a month for 4 months?
I'll put, you'll pay $50 within 30 days and you'll pay $50 per month until paid in full.
Okay.
You're all set.
Thank you so much, Your Honor.
Thank you, Your Honor.
What's your name, ma'am? What's your name?
Keandra Gill.
You have a case number?
Yes, ma'am. 65663. I'm on behalf of Silverstone Townhomes.
Are you the property manager?
I am filling in for the property manager. I am the office assistant to the property.
Silver Townhomes.
Silverstone.
Okay, Silverstone Townhomes. I have 4 files this morning for them, correct?
Yes, Your Honor.
Okay, thank you.
To log in on PC either. Mine was acting up this morning again.
Who couldn't log on?
Day one. But he sent it to me via email, so I can upload it.
Sent what?
The notices to appear that we have to scan into OnBase.
No, you told me you already sent that. That's what I wanted you to tell her. I sent you this, I previously sent it, not just checking that you received the requested information. The reason why
5,000.
Good morning. What's your name that's signed in under the device T Gill?
My name is T. Ambergill. I represent Silverstone Townhomes.
Okay, thank you.
You're welcome.
Good morning. What's your name that's signed in under the Motorola Moto G?
Sure. My name is Cynthia Johnson.
Your matter was dismissed, Ms. Johnson.
Okay.
I'm sorry. on the record in the matters of the city of, state of Michigan versus Kenneth Wright. File number is 24-01855, 24-01856, and 857. You're Mr. Kenneth Wright. Okay, Mr. Wright, I have a file number ending in 55 and 56, a citation for dog at large, and then file number ending in 57 is a malicious destruction of property by a dog. All three are misdemeanors punishable with a maximum penalty of 9 months in jail and or $500 in fines. It says here under the remarks section of the citation, I believe these are the dogs' name, Pretty in Brooklyn ran at large into a neighboring property and attacked the neighbor's dog, causing injury that required veterinary attention. And there's a CAD report number 24-0002646. So you have the right to be represented by an attorney. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at no expense to you. You understand that, right? You have the right to proceed to trial and the right to a jury trial in this matter or these matters. The right to have the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. Otherwise, you're presumed innocent until proven guilty. You understand that? Okay. The court will enter a plea of not guilty on your behalf. Did you want to make a request for a public defender? Is there a public defender in the building? Okay, you're currently scheduled for pretrial conferences. Each of these files is scheduled before Judge Ward on July 1st at 2 p.m. Okay? I don't remember this thing. Did they give him this notice? I don't know if she took it. We'll get you notice to appear for each of these. Let's see. What's your home address?
6227 Marywood Avenue, Michigan, 4911.
Your phone number?
517-377-6018.
Are you employed? Where?
Class Labs.
Okay, if there is a public defender available, they'll do the intake with you today. There should be one, I'm assuming. 10:45, but there's nobody doing arraignments today?
Whereas, has LT. There's
The
somebody in there.
magistrate is doing arraignments today.
I'm getting ready to send the teams to, Nick. They usually do it online.
That's fine. They can log in and we can do it on Zoom. We know who's on this device. It might be Cynthia Johnson. Okay. You have any questions for the court at this time? But you can have a seat. We're just going to see if there's a public defender here. If not, we'll get you the number where you can call to do the intake. For the a dog at large, if you are the owner of the dogs in question, the prosecution would typically like to see that if there's measures put in place to ensure that they don't get out. And typically that will resolve those issues. And then if you get represented, I'm just giving you a hypothetical.
Okay,
Yeah. If you were hypothetically the owner of these dogs, the prosecution would like to see that they were properly secured, maybe with a gate or whatever, and that would resolve the dog at large cases. The malicious destruction of property by dog, that's a matter that you or the attorney would negotiate a resolution with the prosecution for, or you can proceed to trial.
Oh, yeah, I'll pay the neighbors and the vet fees.
Okay, so that you should let the attorney know that, because that could potentially resolve the matter, okay? But your attorney, once you meet with the prosecutor's office, or the public defender's office, can let the prosecutor know that and provide evidence that you pay the attorney, you pay the vet fees. And that may resolve at least the malicious destruction issue, okay?
No one's been hurt.
Okay, give him the number to the public defender's office. And his notice to appear, do you have those?
I do.
don't have them. Who's in the breakout room that's asking for help? Okay, who's on the Samsung device? You need to unmute. You're all set, sir. Thank you.
Hello? Can you hear me? Hello? Hello? Hello?
What's your name, ma'am?
Angela Jones. Can you hear me?
I can hear you.
Okay, because I was trying to run down here because I'm like, I don't know what I'm doing. I don't want to mess up.
No problem. Okay, Ms. Jones is present. Let's see. Did we see Shamira Spearman?
No one's in the hall.
How was service on that? And what about Barbara Lake?
There was attachment executive.
Okay, let's see. Mr. Ozinski?
Good morning, Your Honor.
Good morning. You can submit default for Barbara Lake and for Spearman.
Thank you, Your Honor.
Thank you. Okay, Ms. Jones, I'm gonna play a video for you that will go over your rights. It will go over resources that you may be eligible for to help you avoid an eviction. And then it also will tell you potential ways that you can resolve this matter, okay?
Okay.
Okay, if you can remain stationary somewhere, that's the best way to handle this, because you can.
I'm on my way back in my house now because my daughter was finna trying to run me down here because my body hurts so bad, but I'm on my way back into the apartment.
Okay, I can give you some time because I don't want you to lose your signal.
Oh, thank you. I'm almost there. Okay. I'm all set.
Okay. Give me just one moment. Someone is coming in. Let's see. Did you get lost in the breakout room? I don't understand. Mr. Jason, did you need something?
You. Yes, I did. I was wanting to talk to Mr. Rosa. Is he available?
Yes, we'll contact him and let him know that you want to speak with him. We'll put you in the breakout room and then we'll put him in there, okay?
All right, thank you very much.
No problem. Can you message Mr. Rosa, please? Okay, I'm gonna play the video for you now, ma'am.
Okay.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Okay, hearing date.
June 25th at 2:30.
Okay, Ms. Jones, I'm gonna schedule your matter for a hearing in person at the court, June 25th. You said 2:30?
Yeah.
At 2:30.
Well,
Did you want to meet with legal services today?
um, if that be over the phone? Or
Yeah,
over the,
I would just put you in the meeting room with them right now.
yes, ma'am. I just have one thing. I don't know that I have a surgery coming up a surgery that I won't be able to turn down. I don't know what date that it comes up. So,
Okay, if you are having a surgery between now or the 25th, just have someone let us know and we can
okay.
reschedule it.
Okay.
Okay, and then I'm gonna put you in the room now with Ms. Greco. If you want to also meet with the eviction diversion facilitator, after you finish with her, you'll let Ms. Greco know and we can get Mr. Rosa here, okay?
Thank you.
No problem. What did Mr. Rosa say?
He said yes.
Ju-
He said, okay.
Ma'am, I'm sorry. That's June 25th. At what time again?
At 2:30.
2:30. Sorry. Thank you.
Back now.
Thank you. He's here. You can admit him. Let me see. Angela Jones. Ms. Greco, I'm putting Ms. Jones in room 1.
Thank you, Your Honor.
Excuse me, Your Honor. I have a quick question with regards to an earlier case.
Give me a moment. Ms. Jones, did you get a request to join the breakout room?
I'm sorry. Yes. Just push
Okay,
to join.
Correct. Mr. Rosa, I'm gonna put you in room 3.
Thank you, Your Honor.
Okay, you had a question or something, Mr. Osinski?
Yes, with regards to the Carolina Flats v. Perez case, did Ms. Perez ever show up?
Ms. Perez did show up, and we gave her an export date. I think she's ill. But we gave her the next court date. What day was that for? June 25th at 1:30.
Thank you so much, Your Honor.
Thank you. Who's on the LG K40? Hello, can you hear me on the LG K40?
Good morning. Who just signed in from the LG phone?
I didn't admit her.
Good morning. What's your name? Who just signed in from the LG phone? Hello? Who just signed in from the LG K40 phone? What's your name with the LG K40 cell phone? Hello, the person with the LG K40 cell phone. What is your first and last name?
That's me. Hi, my name is Naisha Wade.
Okay, thank you very much.
You're welcome, Your Honor.
Okay, Naisha Wade. Okay, Ms. Jones, were you all set?
No. Two things is, unfortunately, I misheard you. I thought you said July 25th, and that's the reason I said possibly a surgery. But I will have
June
chemo.
20
You
It's June
right? I
25th?
will have chemo.
On June 25th?
Yes, ma'am. I have chemo
Okay.
4 days a week.
Do you have it every Wednesday?
Yes.
What day of the week do you not have chemo?
I might have 2 more weeks of it.
Okay, let's set this out. You have chemo for 2 more weeks and then you'll be available to come in on a Wednesday?
Yes, ma'am. Like after it's what's July is the first. My last one is the first week of July. Trying to look it up on my barrel. Sorry.
July 16th at 1:30.
July 16th at 1:30?
Yeah.
At 1:30, ma'am.
Okay. Thank you. And also, she said I need to speak to Mr. Dalla Rosa.
Mr. Rosa?
Mr. Rosa, yes, sir.
Okay, I'm gonna put you back in the meeting room and we'll message Mr. Rosa so that he can log in and meet with you, okay?
Okay, that's July 16, 1:30.
Yes.
Right. Okay, thank you.
You're welcome. So we'll let Mr. Rosa know.
I'm sending a message.
Is it Naisha Wade? Oh, yes, I know. Naisha Wade, did you all communicate with her?
Yes, ma'am.
Okay, can you hear us?
Yes, I can hear you.
We're gonna play a video that will go over your rights as part of this pre-trial for an eviction matter. It'll also tell you about resources that you can avail yourself of if you need assistance to avoid an eviction. And then also potential ways that you can resolve this, okay?
Yes, Your Honor.
At the conclusion of the video, I'll get you your next court date. You need to appear in person for that date. And then we also have representatives that you can meet with in the virtual courtroom. We have representatives from legal services. They can do an intake to see if they can represent you for free. And then we